SchnitzelNinja.
My case 26-05144, Elizabeth Naylor and Ronn Owens.
I'll take the appearances in the Naylor and Owens matter.
Good morning, Your Honor. I'm Elizabeth Ann Naylor, appearing pro se, and my husband and co-debtor, Ronald Stephen Owens, is also present with me today representing himself.
All right. Thank you for your appearance, ma'am. And
Good morning, Your Honor. Jennifer G. Imo on behalf of the United States Trustee, and thank you for allowing me to appear by Zoom because I am out of town this week.
all right. Thank you. Good morning. Any other appearances? No. All right. We've just called the Naylor and Owens matter. Counsel, if you'd like to make an appearance in that matter. Okay. All right. Let's go ahead and proceed. All right. So, Ms. Naylor and Mr. Owens, this is your emergency motion to extend the automatic stay in this case. As you are aware from preparing the papers, the automatic stay will expire shortly unless the court finds that grounds exist to find and conclude that you have met your burden of establishing clear and convincing evidence to enable this case to move forward. I did want to clarify a couple of things for you, Ms. Naylor and Mr. Owens. Just some of the statements you made were that U.S. Trustee hadn't proven bad faith, but that's not really their burden. It's your burden to prove that this case was filed in good faith, and you have to have clear and convincing evidence. One other thing I also wanted to advise you is that the court's mortgage modification program is not mandatory. It is a program that can be administered through this court. The creditor, however, is not compelled to participate. When they do participate, of course, there's a requirement to appear and to participate in good faith. But the process is that you request to be in the program, and the creditor can ask to be removed from the program. So I did want to clarify for you that that is not something that the court can require the creditor on your home to do, to participate. Okay. Did you have a question about that?
No.
Okay. All right. So this is your emergency motion to extend the automatic stay. The primary thing that the court is looking at is what has changed between when your first case was dismissed and the filing of your new case. That's really all I'm concerned with. What is your change of circumstances, and what can you tell me to show that this case can move forward successfully? So you've told me a lot of information about your dealings with the creditor, you've indicated that your income is steady, but I can't tell that has been a change from your prior case and when it was dismissed. So why don't you focus on that information?
Well, the prior 13 was dismissed not because we abandoned it, but because our attorney didn't act when I asked him to in writing.
Well, let me just stop and interrupt you there, because I've reviewed the papers filed in the prior case, and the reason your case was dismissed is because you did not turn over to the trustee tax returns, and because your plan payments were delinquent. And I believe, and also you had outstanding objections to confirmation that were unresolved. So whatever may have happened with your attorney, that I don't know what happened there, but filing your taxes and turning over your returns and paying your plan payments are all within your control. Correct.
And as far as the tax filing is concerned, we have had major health issues with my husband I'm his primary caretaker. And I had not filed the taxes because I knew we didn't owe anything at that point, and I had other issues that I was taking care of. And then when we filed for bankruptcy and I wanted to get the taxes filed, I was unaware that when you file for bankruptcy, the credit card companies make it so that you no longer have access online to the prior credit card information. So I didn't
Why
have
is the credit card information something you're telling me about?
to the purposes of deductions and expenses. I had relied on those being available online. So we have since filed the returns for 23 and 24 that were asked for. And so those have been taken care of. As far as the plan payment is concerned, we had some major unexpected expenses that could not be put off. We had major storm damage and cleanup that had been required, and we had septic tank issues, and we had car repair issues, and the money had to go into those things from an emergency crisis standpoint. Going forward, we would anticipate that the amount of income that we have that is guaranteed, the $21,000 a month income that is guaranteed under our Social Security and pension benefits, would be enough to give us the restart that we need here. And also, as far as the payments are concerned, in dealing with SPS, they would send me information that indicated that the entire amount of arrears had to be paid at a time, that it wasn't like you can just make a one monthly payment, that the whole thing needed to be paid. So it seemed like until we could actually talk to SPS and get things clarified with SPS, it didn't seem to make sense to throw money there when they would have the home in foreclosure anyhow.
So let me go back to my question for you, which is, what has changed in your personal and financial situation since the dismissal of the first case and the filing of the second case? Because the guaranteed income you've just mentioned, the $21,000, that was in fact part of the first case. So that's not a change. So what has changed?
Correct. So we also had some expenses with two of the LLCs that we have that are no longer applicable, and so that is a big burden that is off the table.
Could you be more specific?
We had one LLC that had that was an investment in a short-term rental that we had to forfeit. We had expenses, major expenses with that, and we had bookings that were down from that. We also had
so wait a minute before you move on. I guess I don't understand. Your papers didn't tell me anything about whatever it is you were just mentioning, bookings with rental property?
Liz Max Investments. I believe it was listed as zero value in that.
Well, I mean, your motion to extend the stay didn't describe a change of circumstances involving what you've just mentioned. So are you saying that you had some real property that you have surrendered in the interim period? Yes.
So it was an investment that was costing us money, and as I say, it's listed as Liz Max Investments on there.
Okay, so one of the struggles that I'm having in preparing for this hearing, and let me roll back for a moment and just say that the papers you filed are not acceptable in terms of being too lengthy. You cannot file 29-page responses. We have rules about how long papers can be. In some courts, the court will literally take the filing you have filed, find the page limit, rip it off, and throw it away. I did not do that. I read your papers, but in the future, I'm not going to. So your motion and your reply were both too lengthy. But the problem is, I don't have schedules and statements in this case. You've received an extension of time to file those, which was good. I'm glad that you got court authorization to file those papers later. The problem is that they're due at a date that beyond this hearing. So as I'm preparing for your hearing today and reviewing your papers, I still don't have the schedules and statements that you need to prepare under penalty of perjury so that I can really understand the changes. So, for example, you just talked about surrendering a parcel of real property. That was not disclosed anywhere in the papers that I've reviewed today. So I'm a little bit struggling to fully understand your situation. Let me move on and ask you, what other changes have you occurred? So you've surrendered a parcel of real property. What else has occurred?
We had some ponies that were part of our LLC, our Quartet Farms LLC, which we no longer have, and which were costing quite a bit of money monthly on board in Florida. And we no longer have those.
So what is that? You said that property. Was it personal property? Was it real property?
It wasn't. It's not a property that we own. I'm saying that they were boarded in Florida.
What was boarded?
The ponies.
You had ponies boarded in Florida, and you no longer own those ponies?
One of them was sold, and one of them is leased out for the year.
Okay.
Yeah.
All right. I'm not going to be able to consider your emergency motion today until I receive your schedules and statements with full disclosures about what has happened in this case. I think what I will do is I'll hear briefly from Ms. Giamo, and then I'm inclined to give you a short continuance until after the schedules and statements have been prepared and filed so that I can review in writing your situation and I can have a better understanding as to what has changed between the dismissal of the prior case and the filing of this case. But let me ask you this question. Your papers indicated you were looking for counsel. Your case was filed nearly a month ago on May 22nd. So where are you with respect to obtaining counsel?
I have spoken with 21 different bankruptcy firms and attorneys. A lot of them are busy and unable to take the case. I have found one who is willing to take the case. However, because we ended up having to file pro se at the last minute, my understanding is that the post petition, that the retainer fee post petition has to be paid by a third party. So we are in the process of finding a third party to fund the retainer, and then the attorney has told me he would be happy to step in at that point, but that it has to be funded by a third party.
What is the name of the attorney you intend to hire?
Garaman Yusufov.
Okay. And when do you anticipate hiring Mr. Yusufov?
Just as soon as I can find the third party money.
So you don't have that lined up yet?
I am, it was not something I was anticipating having to do. So I'm reaching out to friends and hopefully we'll have something set this weekend so that he could come on board early next week. And I know the amended schedules are due on the 26th and that the 341 meeting is on the 30th.
And so do you intend to retain Mr. Yusufov to attend to complete your schedules due on the 26th?
I would like to. If that timing doesn't work out, then I am committed to this. We are committed to this.
All right. As I indicated, I'm inclined to give a short continuance of this matter and impose a temporary stay under Section 105 because the 30-day period of your bank from the filing of your case is looming, which means that the automatic stay under 362 is about to expire. And I will say that on this record, I do not have clear and convincing evidence that there has been a change of circumstances. But let me turn to Ms. Giamo and hear from her briefly, Ms. Giamo, since you know pretty much what I'm going to do here. Thank you.
Thank you, Your Honor. Yes, thank you. Well, the first thing I want to point out is that, Your Honor said that you don't have the schedules and statements, but we do. We actually do have schedules and statements that were filed at docket 9 in the case. And that's a large part of the U.S. trustee's objection, is the fact that there's huge misrepresentations in there. This was not a situation.
And you were correct. I'm sorry. Let me interrupt and just say there are schedules and statements. They are, in the debtor's term, skeletal, which is essentially non-existent. So, and my apologies, but for the record, I will concede something was filed.
Thank you. And actually, I would definitely disagree with their claim that this was a skeletal petition. As Your Honor knows, many debtors file a petition, but they don't file schedules and statements, and they end up asking for an extension of time to file them. That's not what happened here. Mr. and Mrs. Owens, what they chose to do was file schedules and statements that were false. And that's just another indicator of their bad faith, and that they would choose to file schedules and statements knowing that they were signing them under penalty of perjury and knowing that they contained false statements. They should not have filed anything. Or if at the very least, they could have left everything blank, but they didn't. So I just want to point out that that's a very key thing. And the other thing is, Your Honor, my understanding is that the court's decision has to be made before the 22nd. Or once the stay terminates, that's it. So I don't know when Your Honor wants to reset this hearing for, but I would argue that you have sufficient grounds before you right now to deny this motion, because, as Your Honor pointed out, there is no clear and convincing evidence. There's no evidence at all in this case that there's been a change of circumstances. There were no change of circumstances that were listed in the motion, and there were none that were listed in the reply after I specifically pointed out in our objection that they needed to show that. There is no change in circumstance. And they will not be able to show that unless there's going to be more misrepresentation and there's going to be more inconsistencies between the various sworn statements they make. And I just don't think that these debtors should have another opportunity to make more false representations under oath to this court. I think the time is now to say what I have on the record is sufficient to show that to show that the case was filed in bad faith. First, because there's a presumption of bad faith, because there's no change in circumstance. And second, because of all the reasons the U.S. trustee outlined in her objection, which is that there's a lot of evidence here of misrepresentations, egregious conduct. I want to address one minor last thing. Well, it's not minor. In their reply to the state's trustee's objection, the debtors claimed that they never received notice of the initial debtor interview. And I'm going to take issue with that. And I'm going to say to Your Honor that we have a paralegal who mailed the notice of the initial debtor interview to the address listed on the docket sheet. That paralegal would be prepared to come in and testify under oath that he mailed out that notice. I find it extremely odd that Mr. and Mrs. Owens claim they did not receive that notice, but yet they were able to receive my objection to their stay extension, which was also sent by first-class mail. There was no email address on the record. So as Your Honor knows, we were required to serve these pro se debtors by first-class mail. That was the only method that we were allowed to send them service of the notice of the IDI, the initial debtor interview. And they completely ignored it. They didn't show up. That messes up the schedules of people in my office. And I think that by allowing this case to continue and giving these debtors an opportunity, even a short one, to try to file new schedules that might have, again, more misrepresentations, all we're doing is postponing the inevitable and allowing these debtors to continue abusing the system. And that's what this is. Thank you, Your Honor.
All right. Thank you, Ms. Jamo. And I appreciate the position of the U.S. trustee. And I certainly have no issue with the mailing of the IDI to the debtors, and I don't understand why they assert they haven't received it, since under the mailbox rule, the presumption is that they did in fact receive that. I do not have sufficient information. I do know the debtor's motion for extension of time to file or amend the schedules did indicate that they understood that they were skeletal. I mean, I do think that there are certain discrepancies that need to be explained if they can be. But on this record today, I'm not prepared to lift the stay, given that this is the debtor's primary residence and time is short, and they filed under, it sounds like, some dire circumstances. So I will exercise my discretion to impose a stay under Section 105 for the temporary period for the court to determine whether a further stay is appropriate under the circumstances. I hope I have articulated to Ms. Naylor and Mr. Owens the court's concerns, and that on this record it does not appear that there has been a sufficient change of circumstances. But I will wait to see what the schedules and statements indicate, and I would ask again that the parties follow the rules when they file the papers. I know Ms. Naylor's papers complained that the creditor's objection, which has been withdrawn, was not timely filed because it was several hours late. And if she's going to make the complaint that others should follow the rules, I would remind her that she needs to follow the rules as well. So with that, let me turn to Ms. Hall and get a continued hearing date. And I'm looking for something shortly after June 26th and probably after June 30th, which is the 341 date.
Yes, Judge, we can set that for Wednesday, July 1st at 2 p.m.
All right, Wednesday, July 1st at 2 p.m. Ms. Jaimo, will you be traveling? Do you need to appear by video? Oh, you're on mute, ma'am.
I apologize, Your Honor. No, I will be home from vacation by then.
All right, thank you. So with respect to the IDI, has that been reset, and will it be reset after? I mean, I think you need the papers in order to proceed.
Yes, Your Honor. So I left the office. I was left town on I believe Friday. So I have not been in communication. I don't have my work computer. I will have to reach out when I get back on Monday, and I will talk to the bankruptcy analyst and the paralegal who handle the scheduling of the IDI. But yes, obviously it will need to be rescheduled, and those documents will have to be given to the U.S. trustee before the 341 meeting. So actually, I do want to point out that if we do have, and I'm fine with Your Honor having the hearing go forward before the 341 meeting, but we will in all likelihood need to continue the 341 meeting because we need sufficient time for the analyst and the paralegal to reschedule the initial debtor interview, and then I will need time to be able to review with the documents before they come in for the meeting of creditors. So, like I said, I'm fine with the July 1st date to have this matter continued, and we can always do the 341 meeting after that.
Well, I am. I'll let your office, of course, handle it. That's your office's prerogative, and you handle those. That's not a court matter. It's a matter through your office. I was just going to say it's unusual for the court to have granted an extension to file schedules to the 26th, given the 341 is on June 30th. I typically require those papers at least a week before the 341, and so I do see that this is a bit of a time crunch where those papers are due on Friday and the 341 is on Tuesday. So I appreciate your office's need to have a quick turnaround. So Ms. Naylor and Mr. Owens, I'm going to direct that you email those documents to Ms. Jaimo's office, as well as filing them with the court's records so that she will have them as soon as possible.
And which documents specifically are you talking about?
The documents that Ms. Jaimo has requested and the amended papers you're planning on filing.
The amended schedules then?
Correct.
Okay. All right. Your Honor, may I say one more thing?
Just a moment. I have a question from the court. What is that?
Yes, we got a message from Helen in the chat asking about, I'm guessing the court to ask about GoFundMe.
Ma'am, you are appearing by Zoom, as is Ms. Jaimo and others, and apparently there was a query to the court deputy through the chat system requesting the court to ask you about information where you have set up a GoFundMe site. Did you wish to address that?
Your Honor, I imagine this has to do with the smear campaign, which has been going on against our family for the last 3 years. A GoFundMe was set up on behalf of my husband by friends, and that was set up in December of 2024, and it was set up at that time in an effort to try to help us prevent the bankruptcy situation.
Your Honor, may I, if I can just intervene here real quick? I think what the issue is that there was a GoFundMe set up in the name of Mr. and Mrs. Owens, and I think there was over $100,000 generated, and that was never disclosed in the Chapter 13 or in this case. That's what the issue is. And that was something that I was going to delve into in the 341 meeting.
Okay. All right, thank you. Let's go ahead and wrap up this meeting, this hearing. Did you give me the hearing dates and times?
Yes, I did, Judge.
We apologize.
Yeah, that's July 1st at 2 p.m.
So July 1st at 2 p.m., we'll resume this hearing. The court will impose a temporary stay or extend the Section 362 stay via Section 105 temporarily until the conclusion of that hearing, when the court can consider in a more fulsome manner the schedules and statements that are forthcoming, the amended schedules and statements, and any other papers. And again, I've directed Ms. Naylor and Mr. Owens to email to Ms. Jaimo any papers that they file with the court, and also the papers for the IDI. And with that, I believe everything is concluded at this time. Is there anything further? Ms. Jaimo, I see your hand.
Yes, Your Honor. I just want to clarify, are you allowing the debtors to refile more pleadings in support of their motion after filing the amended schedules? And if so, I would ask that I would be given an opportunity to reply.
I actually have not asked for that.
Okay.
But
that's I prefer that, Your Honor. I think that the schedules should speak for themselves. So.
I agree. We have a motion, we have a response, and we have a reply, and that's all the court needs. Okay.
Very good.
All right. Any other questions or concerns, Ms. Naylor or Mr. Owens?
Yes, I have. So the 341 was scheduled for the 30th. Where does that stand?
It's still scheduled on that date and time.
On the 30th. Okay. And the continuance is July 1st. Okay. And the other thing is, I wanted to sincerely apologize with regard to the IDI. We did not get any notification in the mail about that. And I have gone back, because I get daily notifications from the U.S. Postal Service with photographs of every piece of mail that I'm getting that day. And I have gone back and looked at the mail that was delivered, and what was in there for every day since we filed on May 22nd. And there was nothing that came to us with regard to an IDI or anything like that. So I have looked, because I thought, did I miss it, or, and it was not on the docket. And in fact, I had called.
It doesn't belong on the docket, and the court would have nothing about it. Let me just ask Ms. Jaimo to email whatever it is she's requesting directly to you, Ms. Naylor and Mr. Owens, and we'll move on. This hearing is concluded. Thank you.
SchnitzelNinja.